Marcus thought he was fine. 2 drinks with his boss after work and a short drive home. What can go wrong, right? Well, red and blue lights in his mirrors. By the time the night was over, he had an arrest for a first-time California DUI on his record. His car was impounded. He had no idea what came next. And most people don't. The next 30 days are the ones that actually determine your future. I'm Dmitry Gurovich, and after 30 years as a criminal defense attorney in California, I've seen this exact story play out hundreds of times. Here's what actually happens next. Let's start with something nobody tells you at the scene. When an officer hands you a pink temporary license after a DUI arrest in California, there's a clock that starts ticking immediately. You have 10 days to request a DMV hearing. 10 days. If you miss that window, the DMV automatically suspends your license, and you lose your shot to challenge it. This is not a court thing. This is a completely separate process run by the California Department of Motor Vehicles, running parallel to your criminal case. 2 different systems, 2 different sets of consequences, 2 separate fights you need to win. Most people don't know this. They get home rattled. They tell themselves they'll figure it out next week, and then the suspension kicks in. In LA, losing your license isn't an inconvenience. It is a crisis. Now, let's talk about the DMV hearing. What is a DMV hearing? A DMV hearing is an administrative proceeding. No judge, and it's usually done over the phone. But it matters enormously. At the hearing, you can challenge whether the officer had legal grounds to stop you, whether the field sobriety tests were conducted properly, whether the breathalyzer was calibrated and functioning correctly. These aren't technicalities for their own sake. They're legitimate defenses that can prevent your license from being suspended at all. If you don't request the hearing and no lawyer steps in immediately, that option closes permanently. The suspension kicks in automatically. For a first offense where you don't refuse the chemical test, that's typically a 4-month suspension. And if you refused, it's a whole year. Now, let's talk about the court case itself. The criminal side is where most of the fear lives, and that makes sense. This is where a conviction goes on your record. After a first offense DUI in California, you'll be arraigned. That's your first court appearance, usually within days to a few weeks. You'll hear the charges and enter a plea. And a lot of people think this is the moment to say guilty and get it over with. They're embarrassed. They don't want to keep showing up to court. They want to move on. The instinct is almost always wrong, however. Here's why. At arraignment, the prosecutor hasn't dug into the evidence yet. They're filing the same charge they file on every single DUI. They don't know whether the breathalyzer had maintenance issues, whether the officer followed proper protocol, whether your blood alcohol was actually rising at the time of the test because you had your last drink 20 minutes before getting in the car. A defense attorney orders the maintenance logs. They pull body cam and dash cam footage. They review whether the field sobriety test was administered correctly, given the road surface, the lighting, and your footwear. These are real issues raised in real courts regularly. After arraignment, pretrial hearings allow evidence to be exchanged and motions to be filed. A suppression motion argues that the evidence against you was obtained illegally and should be excluded. If the officer didn't have reasonable suspicion to stop you in the first place, everything that follows can be thrown out. Everything. Now, let's look at the penalties. What are you actually looking at? Well, let me be specific, because vague warnings don't help anyone make a real decision. A first offense DUI conviction in California typically carries fines and fees ranging from about $1,800 on the low end to well over $10,000 when you factor in court costs, penalty assessments, and DUI program fees. The base fine is manageable, but the total bill is absolutely not. A driver's license suspension of 6 to 10 months through the courts can stack on top of the DMV suspension. Restricted licenses are available in many cases so you can drive to work, but they come with conditions and require an application. There's also a DUI school. This is a state-certified alcohol education program running either 3 months or 9 months, depending on your blood alcohol level at the time of the arrest. And it's not optional. It's required to get your license back. There's also probation, typically 3 to 5 years of informal probation, meaning no probation officer check-ins, but conditions you have to follow. Violate those conditions and you're back in front of a judge. There's also possible jail time. On a first offense, with no aggravating factors, many defendants avoid actual incarceration, but the court can impose up to 6 months. Some counties are more lenient than others. And then there's your insurance. Carriers frequently drop clients after DUI conviction or spike rates significantly. Expect to pay more for years to come. Now, why is it worth reviewing the evidence? Well, the breathalyzer issue alone deserves its own discussion. Those devices require regular calibration and maintenance, and officers must follow specific protocols to administer the tests. Results can be affected by residual mouth alcohol, certain medical conditions, and whether the required 15-minute observation period before the test was actually followed. This isn't speculation. These documented issues come up in court constantly. I've seen cases where a breath reading of 0.10 led to a reduced charge because the stop itself was legally shaky. I've seen prosecutions fall apart entirely because the officer skipped a required step. Even if the breathalyzer reading is solid, was the stop legal? Did the officer actually observe specific DUI indicators? Or did they notice a minor lane drift and just run with it? These are the questions a defense attorney asks before anyone decides anything. So what happens when you hire a defense attorney? Well, the first move is getting complete discovery. Police reports, video footage, breathalyzer maintenance records, the officer's training history. We look for procedural defects and evidentiary problems. We file motions where they apply. We negotiate from a position of knowledge. In some cases, charges get reduced to wet reckless, which is reckless driving with alcohol. It carries lighter penalties, and it doesn't count as a DUI for future purposes. It also has less impact on your insurance situation. In some instances, the entire DUI case can get dismissed. The goal isn't just a few months. A DUI conviction follows you on background checks, professional licensing applications, and certain security clearances for years. And don't forget possible immigration consequences. The cost of a competent defense almost always makes more financial sense than the long-term cost of the conviction on your record. If you want to know what happens on a second offense or when there's an accident involved, that video is next. Comment below. Did you know about the 10-day DMV window before watching this? I am actually curious how many people find out too late. If you need to talk through your situation, DG Law is at Crim Law LA. Subscribe if you want the rest of this series. Thank you.